In the comment box of my last video, I was suggested to make one video in respect of section 9 of CPC. So today, with due respect of that comment, let me make this video. Section 9 of CPC says, courts to try all civil suits unless barred. The court shall have jurisdiction to try all suits of a civil nature. Of a civil nature, meaning thereby the suit must be having civil nature. Otherwise, the court has no jurisdiction. Now, another line of that provision says, excepting the suits of which their cognizance is either expressly or impliedly barred. This is the provision, and thereafter two explanations are given. So what are the ingredients of section 9 of CPC? First, the court shall have jurisdiction to try all the suits of a civil nature. Second, the court shall not have jurisdiction if cognizance of a suit is barred either expressly or impliedly. So this is the condition imposed by the legislature as far as the jurisdiction of a court is concerned in respect of the suit of civil nature. Third ingredient or third question, which suit is considered as a suit of civil nature, or which type of suits are considered as a suit of civil nature? Answer, where a right of a property or to an office is contested in a suit of civil nature. This is an explanation given in the provision. Second, in a suit, if the question is in respect of religious rites or ceremonies, and the right may depend upon entirely on the decision of such question, such suit can be considered as civil nature. The suit, it is possible that the suit is related in respect of religious ceremony or rites. Whether that type of suit can be considered as civil nature, the answer is yes, it can be considered as per the explanation given in the provision. Now, one clause is given in that provision, notwithstanding. Notwithstanding is a clause, is a non-obstant, OBSTANTE, non-obstantive clause. What does it mean, non-obstantive? It means provision is prevailing over anything which is contrary to the provision. Non-obstantive, notwithstanding is mentioned in that provision. That is why I have just explained this. It is further explained in explanation 2 that any fees related to any office is not relevant or is irrespective. Second thing, one is not material, such office is attached to a particular place. Whether the office mentioned in explanation number 1 is attached to any particular place, that is immaterial as far as the purpose of section 9 is concerned. This is the explanation of section 9. Now, which type of suits are barred as far as section 9 is concerned? The suits relating to the acquisition proceeding, acquisition of land proceeding, is not maintainable. Cognizance of such suit is barred under section 9. This is said by Honorable Supreme Court in one judgment. SP Subramanya Shetty versus Karnataka State Road Transportation Corporation, AIR 1997 SC, para number 4. Second, suit against constitutional scheme. Constitutional scheme, just one example in respect of Article 341 and 342 of the Constitution of India. 341 is related to scheduled caste, 342 is related to scheduled tribes. Now, suppose a person after conversion of his caste or after conversion his religion can claim that now I want to be in particular caste mentioned in Article 341 or 342, or can file a suit in this regard? The answer is no. Supreme Court said no, you can't. The judgment is S. Swingarados, SWVIGARADOSS, it is maybe South Indian name, versus Zonal Manager FCI, para number 8. Supreme Court says suit is barred by Section 9 because it is not the suit of civil nature. Third, Section 22 of the Environment Protection Act 1996. Whenever it is mentioned in any particular act or statute that barred of jurisdiction, civil court has no jurisdiction. Under such circumstances, there is applicability of Section 9. Section 58 of Water Act, this is an example, and Section 7B of Indian Telegraph Act 1957. Civil suit challenging the correctness of bills would not be maintainable. Honorable DB, Division Bench of Gujarat High Court, in the case of GP Chowatin versus CGM Gujarat Telecom Circle, AIR 1996, Guj 153, para number 9, has held this. Another question or another point, questioning the demand of professional tax under Punjab Municipal Act 1911. Case is Munsiram versus Cheharatra Municipality, AIR 1979 SC 250. Under Income Tax Act, no suit shall be brought in any civil court to set aside or modified any assessment made under the act. Then industrial disputes, of course, jurisdiction of civil court is barred as far as the suit or dispute is in respect of industrial or under the purview of under Industrial Act 1947 is concerned. This is the case City Nikam versus Municipal Corporation Ahmedabad, AIR 2002 SC 997, wherein it is said that dispute under Industrial Dispute Act is impliedly barred. Now, one judgment of Honorable Supreme Court is very important as far as Section 9 is concerned, because in that judgment 7 principles are laid down by Honorable Supreme Court. I'm not going to read entire 7 because it is lengthy and to cut short my video. Just I am going to give the name of that judgment. Dulabai versus State of MP, AIR 1969 SC 78, para number 35. wherein Honorable Supreme Court laid down the principle in respect of sections, applicability of section 9 of the Civil Procedure Code. So friends, to conclude my video, if a suit is of civil nature, civil court has jurisdiction. If there is specific provision in a special statute that in the line just bar of jurisdiction, and it is mentioned then civil court has no jurisdiction. Under such circumstances, whenever a special statute says that civil court has no jurisdiction, then there is an applicability of section 9. Further, if the validity of any acquisition proceeding is sought as a prayer in any suit, then civil court has no jurisdiction. Friends, I hope you like this video. Thank you very much.